discussion powered by Phoenix Legal. We would be exploring the turf of emergency arbitration on this video today. So to discuss this, we have some great experts with us. We have Ms. Julie Raneda. She is partner International Arbitration Group at Schellenberg Wittmer based in Singapore. We have Mr. P M Devaiah. He's the Group General Counsel of Adani Group. And with him, we have Mr. Vasanth Rajasekaran. He's partner at Phoenix Legal, also an expert in arbitration and litigation. Welcome, guys. Thank you for taking time out for us. To begin this discussion on exploring the turf of emergency arbitration, I would request Vasanth to share a few lines on the topic and introduce this to our audience today.
Thank you, and I'm good to be a part of this panel to discuss the emergency arbitration. While we continue to institutionalize the Indian arbitration landscape, there is a need to integrate the global best practices of institutional arbitration. One such example is the concept of emergency arbitration. Emergency arbitration especially includes brief and rapid hearings, often conducted at a short notice for granting interim reliefs. Even sometimes it happens within 24 to 48 hours. Emergency arbitration as worldwide phenomena has gained prominence only a decade ago in the vast history of international commercial arbitration. The Stockholm Chamber of Commerce and the Singapore International Arbitration Center were the first two institutions to have introduced the rules and procedures for conducting emergency arbitration in the year 2010. Presently, emergency arbitrations are prevalent across the world at institutions such as ICC, AAA, HKIAC, etc. Coming to the Indian context, India recognized the global trends, and the Law Commission in its 246 report had recommended an amendment to the definition of arbitral tribunal to include the emergency arbitrator. However, the recommendation of the Law Commission of India was not given any legal sanction by the Parliament. Hence, the present scheme of the Arbitration Act does not contain a definition of emergency arbitration or does not deal with any provision that deals with emergency arbitration. The broader concept of granting interim reliefs by the Arbitral Tribunal is incorporated under Section 17 of the Indian Arbitration Act. The interim reliefs also can be undertaken by the courts under Section 9 of the Arbitration Act. Insofar as institutional arbitration in India is concerned, rules for emergency arbitration have been developed by institutions such as Delhi International Arbitration Center, Mumbai Center for International Arbitration Center, Indian Council of Arbitration Center, Nani Palkiwala Arbitration Center, etc. In this context, we will be exploring the turf of emergency arbitration in the Indian arbitration landscape vis-a-vis the global trends.
Thank you, Vasanth. Thank you for giving us this introduction for our audience. Moving on further, as we talk about the Arbitration Conciliation Act, it also provides for interim measures under Section 9 and 17 of the Arbitration Conciliation Act that we have. So how does emergency arbitration differ from the interim relief that can be sought under this Act? Vasanth, if you can share your thoughts on that.
Thank you. The prominent difference between Section 9 and Section 17 lies in the scope of operation of these provisions in the Indian Arbitration Act. Section 9 empowers the court to grant interim measures for preservation of the subject matter of dispute and preventing irreparable harm to one of the parties to the arbitration. Whereas Section 17 provides similar power to the Arbitral Tribunal as that of Section 9 in the scheme of the Arbitration Act. So Section 17 comes to play once the Arbitral Tribunal is constituted. So as regards emergency arbitration, emergency arbitrations are also specifically conducted for granting interim reliefs or getting interim awards. These are akin to mini trials dedicated for granting interim reliefs. As I said in the introduction, emergency arbitral tribunal is constituted in a much shorter time, sometime in 24 to 48 hours time. Now let's see the challenges faced with emergency arbitral decisions in an Indian arbitration scheme of act. The enforcement of emergency arbitration decision is the most challenging aspect. That can be either an order or award under the emergency arbitration. Foreign emergency arbitral awards will have to meet the condition of enforcement under Part 2 of the Indian Arbitration Act. I am referring to the PASL win solution decision here. Alternatively, emergency arbitral tribunal may pass an order under Section 17. Such an order also must pass the muster of provision under Order 21 of the CPC when it comes for enforcement. So therefore, in both cases, be it an award or an order from the emergency tribunal, an enforcement and execution petition has to follow. So whereas Section 9 per se is enforceable, of course it is appealable under 37, but you need not get into the conundrum of going for enforcement and execution petition while enforcing an emergency arbitral award. So interestingly, post 2015 amendment to the Arbitration Act, Section 9 now covers both Indian and foreign seated arbitration. So therefore, in case of foreign seated arbitration also, parties may approach Section 9 and get relief, because Indian courts are having power to grant relief under Section 9 even for the foreign seated arbitration in a series of judgments with the Supreme Court, starting from Helico Charters, Raffles Design, etc. So once the Section 9 order is passed in favor, there is no need for any special proceedings to determine its enforceability. So therefore, it will be prudent for the parties to opt for interim measures under Section 9 of the Arbitration Act. So therefore, interplay has to be, if it involves a mini trial, then of course you go for emergency arbitration. But if it involves prima facie, the case is in your favor, it's better to go for a Section 9. That's how the interplay is framed under the Indian scheme of the Arbitration Act.
Thank you, Vasanth. Thank you. This actually takes us to our next question that we were, you talked about. Basically, what role does party autonomy here play in the status of emergency arbitration in the Indian arbitration landscape?
Party autonomy is a fountainhead of arbitration jurisprudence in India. Our Indian Arbitration Act is based on UNCITRAL model law. Article 19 of UNCITRAL model law provides for party autonomy in international commercial arbitration. That is where the concept of international, that is a concept where the party autonomy has been picked up from the UNCITRAL model law and incorporated in the Indian Arbitration Act. The Indian Arbitration Act also have a similar provision. In addition to the scheme of act which recognizes a party autonomy, which is a fountainhead of arbitration jurisprudence, the Supreme Court has time and again recognized the party autonomy is a guiding spirit of Indian arbitration jurisprudence. You can see in various judgments, including the Balco judgment and Centro Trade judgment, where Supreme Court recognized the party autonomy as a fundamental fountainhead of arbitration jurisprudence in India. So therefore, principle of party autonomy provide parties the freedom to decide upon how the arbitration would be conducted. The Arbitration Act also empowers parties to authorize any person, including an institution, and the procedure to determine the dispute. So therefore, even if a party agree for an emergency arbitration in their contract, furtherance to the party autonomy, so therefore it also has a statutory recognition for the purpose of enforcement and execution.
Thank you. Julie, your thoughts on the question?
Thank you. Maybe just really one quick word from the Singapore perspective. We do not have, if you want, the same issue or maybe uncertainty in Singapore, because the Singapore legislator has taken active steps toward ensuring that party autonomy is respected when it comes to emergency arbitration in Singapore, by making it clear what parties agree to under the Singapore framework, thereby removing any doubt in this respect. And I'll come back to that in more detail later, but generally speaking, and I think Vasanth stressed it very well, party autonomy is at the center, really at the core of international arbitration, not only in India, but everywhere. And in this respect, I think, the Indian solution as presented by Vasanth is very sensible and show a pro-arbitration stance, which is most welcome.
Thank you, Julie. Thank you for sharing that. PMG, do you want to say something, or should I move on to the next? Yeah.
So let me add a very short, perspective here. I think, while speaking for the business side, the business aspires that dispute resolution should be very quick and very efficient. I think that's the need for the business in today's context. Now, my aspiration, or I'm sure the business aspiration would be that party autonomy should be pushed to the maximum extent possible to make arbitral process a very neutral, independent process with least institutional or conventional court intervention. And I think the day we are able to achieve that kind of an autonomy in the true classical sense, where there is least intervention, I think the concept of party autonomy has gained its credence in its full glory.
Yeah, that's well said, PMD. That is true. So that actually, taking it further, as we were discussing about the SIAC as well. So SIAC was the first arbitral institution in Asia to have provisions in place as early as 2010 for appointment of emergency arbitrators. So what lesson can one learn from the Singaporean experience? And I think Judy would be the first one to actually answer this, having first-hand experience there. Please, Julie.
Yes, thank you, Sanya. So you're right. SIAC was the first international arbitration institution to introduce emergency arbitrator provisions with the Stockholm Chamber of Commerce just a couple of months before. The ICC came later, and the LCIA also later in 2014. So SIAC was, and I think still is, really at the front line for emergency procedure in international arbitration. And as of 2020, SIAC has accepted 114 emergency arbitrator applications, so quite a substantial number. Following the introduction of the emergency arbitrator procedure under the 2010 SIAC rules, the Singapore legislature amended the Singapore International Arbitration Act, which governs Singapore-seated international arbitration in June 2012, to make clear that the term arbitral tribunal under the International Arbitration Act includes also the emergency arbitrator appointed pursuant to the rules of arbitration agreed to or adopted by the parties. So it follows that all the provisions under this act relating to an arbitral tribunal's power to make orders or directions, including precisely ordering interim relief and the enforceability of said orders or directions in Singapore apply to emergency arbitrators. So this has arguably led to a high rate of voluntary compliance with emergency awards, because it leaves no doubt as to the nature of the order issued by the emergency arbitrators. Now, in 2016, to address users' concerns and demand for faster emergency relief, the SIAC rules were amended such that the emergency arbitrator must be appointed within 1 calendar day, as opposed to 1 business day in the past. And the SIAC rule 2016 also now requires the emergency arbitrator to issue an interim order or award within 14 days of his or her appointment, while there was no such deadline before. The emergency arbitrators' fees were also now fixed as at 25,000 Singapore dollar and no longer depend on the quantum in dispute. So this also provides, with greater certainty on cost for users. So now, what are the lessons we can learn from the Singapore experience? I think, after the 2012 amendments, especially in the International Arbitration Act, SIAC saw a sharp increase in the number of emergency arbitrator applications. And no doubt that this is due to this formal recognition. This also makes sense as 79% of respondents to the 2015 Queen Mary Whiten case international arbitration survey considered the enforceability of the emergency arbitrator decision to be the most important factor influencing the decision, that choice between recourse to state courts and the emergency arbitrator. And the move towards faster emergency arbitrator proceedings in the 2016 SIAC rule can also be seen as a response to users' demand for faster and more certain timelines regarding this type of proceedings. So, and finally, I think there is also now a practice and an expertise in emergency arbitration in Singapore, which also contributes to make Singapore, so successful as a place of arbitration.
So then that takes us to our next question, which talks about and why basically, emergency arbitration is referred to. So how do arbitrators decide upon the emergent nature of the relief sought? So are there any broad indicators that would enable an arbitrator to weed out pleas that do not merit the initiation of emergency arbitration? So to start with, I would like to ask Mr. Devaiah if you can, share your thoughts here.
Yeah, thanks, Anya. So the answer, to your question is quite sterile and very technical. So let me take the liberty of layering a perspective and then come to your question. So that's what I'm going to do here. Now, it's a jurisprudential irony that we are talking about emergency arbitration. Let's step back in time for a bit. Now, we had a problem with the conventional dispute resolution through conventional courts. So that's the reason arbitration law in the first place was invented. Now, to my mind, the existing arbitration laws are self-contained. They are very rhythmic, and if you see sections of interim relief, pre-formation of the tribunal or during the process, everything is very, very, very well set. Now, there is an attempt now to bring in the concept of emergency arbitration. So that leads to a couple of questions in my mind. I mean, I don't have any answers, but these are questions. Are we trying to complicate matters? Is the simple solution elusive? I mean, I'm reminded of an anecdote where, astronauts, when they landed up in space, apparently they had a great difficulty in writing because the pens wouldn't write due to gravity. And a lot of time, resources were spent in inventing an anti-gravity pen until somebody quickly realized that a pencil could be a easy solution. So are we missing the larger point here in trying to contrive something is the question. Then the next question which comes to my mind is, are we creating a jurisprudence of impatience, right? Well, because see, emergency arbitration by very nature simply means that there is a tatkal justice which is being sought. Now, the faster you do, there's a saying that justice hurried is justice buried, right? So is it good for all of us is the question. And finally, the question which I ask is the chase for a holy grail which is not there? So I mean, I don't have answers, but these kind of questions play around my mind. And coming to answer your question, of course, I think there are two fundamental principles to do the test of emergency. The two principles are as follows. So first principle is a principle called fumus boni iris, which simply means that there's a presumption of a sufficient legal basis, to get a relief. The second one is a principle called periculum in mora, which means the danger in delay, the doctrine of harm, right? So if the measure is not granted immediately, the loss would be and could not be compensated by virtue of a damage. I think these are the two tests. And these two tests are very well established, in jurisprudential areas. And, of course, there is a level of selectiveness, there is a level of subjectivity, there is a level of speculativeness, because it all depends who actually sits and decides what is prima facie and what is not. So that's pretty much on the emergent test for you.
Julie, do you have any thoughts on this?
No, maybe just two words on the standards, applied in international arbitration. I think Devaiah has set out them very well. They are the main, criteria to grant interim relief in international arbitration. They are developed, in the international practice. Now, in some jurisdictions, other criteria, other tests have been developed by the state courts and are sometimes, referred to at the, in those jurisdictions, even by the emergency arbitrators. But generally speaking, I fully agree with the test Devaiah has set out.
Thank you. So that takes us to our last question, which is, to all of you. So basically, given that presently there is no statutory recognition according to emergency arbitration in India, would the binding value of interim measures or emergency arbitral awards be diminished or hampered by any means? And we all know that this is an issue that India is facing today. A lot of litigations and high-profile litigations are happening here.
Sure,
Yeah.
I can start, but maybe unlike in India, emergency arbitration are recognized under the International Arbitration Act. This is clear, and an emergency arbitrator's orders are enforceable in Singapore with the leave of the High Court, in the same manner as if they were, orders made by the court. So, should such leave be granted by the High Court, a failure to comply with the emergency arbitrator's order may amount to a contempt of court, which also goes back to the point I was making earlier about high rate of compliance in Singapore. Now, of course, the question is quite different when such award must be enforced in a foreign jurisdiction like India, which does not have express provision in place to recognize emergency arbitrator orders like in Singapore. But maybe my colleagues can better speak to that.
Yeah. I would like to add some points to what Julie said. From the Indian Arbitration Scheme of Act, the lack of statutory recognition has made certainly a dent in the viability of emergency arbitration for Indian parties. The principle of party autonomy permits parties to elect for emergency arbitration proceedings. However, there are several procedural anomalies and challenges parties likely to face once emergency arbitration proceedings are over. For instance, at the time of enforcement, the moot question that would arise is whether the emergency arbitral award are deemed to be an order under Section 19 of the Arbitration Act or interim award. From the perspective of parties challenging the emergency arbitral award, if an emergency arbitral award is treated as an order under Section 17, then appeal against it would lie under Section 36. So if the emergency arbitral award is treated as an award, then it has to be set aside under Section 34 of the Arbitration Act. For a foreign-seated arbitration award, a challenge would lie at the time of enforcement under Part. These lacunas certainly would shake the confidence of parties to offer emergency arbitration, even though the party autonomy is recognized and the parties agree for emergency arbitration. But the scheme of the Arbitration Act plays out differently. So that is the biggest controversy, as rightly inferred by Sania in the question. The Amazon and the future dispute, the Delhi High Court single judge held that the emergency arbitration, the order passed by the Singapore SIAC, is treated as an order under Section 17. But now the controversy has been moved to the Supreme Court. The Supreme Court reserved the judgment, and we are waiting for the outcome of the judgment to which will evolve the jurisprudence with respect to enforcement of emergency arbitral awards or orders in India.
Thank you. Devaiah, would you like to add here?
Yeah, I mean, both the panelists have already covered, but all that I can say is I think the single judge of the Delhi High Court has given a light touch recognition, to emergency arbitration. I think, assuming that it's going to stay, it's a good start. But the only caution and caveat, which I would like to mention here is, these orders, which are kind of sought and, got in emergency arbitration should not be sought in a hurried manner by using subterfuge. And, that's going to destabilize and disturb the equilibrium of justice to a great extent. So, again, I go back to my principle of, justice hurried is justice worried. So, so long as, adequate bells and whistles are, developed around the process, even if it is emergency, I think it's fair enough to get its due recognition.
Thank you. Lastly, I would request Vasanth if you can give us a good conclusion for our discussion here.
Thank you, everyone. Introducing statutory definition for emergency arbitration would certainly aid us in our journey of embracing institutional arbitration in India. However, until the introduction of such an amendment, we must continue to rely upon the Indian courts for giving shape to the jurisprudence concerning emergency arbitrations. Interestingly, the Honorable Supreme Court in a recent landmark judgment in the Amazon Future matter has held that emergency arbitral awards or orders under 17(1), which should be enforceable under 17(2) of the Indian Arbitration Act. The judgment is a big leap forward for Indian arbitration landscape, as the apex court has bestowed statutory recognition to the emergency arbitration. Through this step, the Supreme Court has reinforced the underpinning principle of party autonomy, which is fundamental for parties adopting arbitration as an alternate dispute resolution mechanism. Given the high-stake commercial arbitrations at play, recognition of emergency arbitration is a dream come true for business, which always look for speedy resolution of disputes. The judgment is a welcome boon for adoption of emergency institutional arbitration by international conglomerates at both domestic and international levels. The Supreme Court decision has certainly set the ball rolling in the right direction and has propelled the Indian arbitration regime to flourish in the coming years. Given the pro-arbitration stance that the legislature and the Honorable Supreme Court have adopted at many occasions in the recent past, including the Amazon Future case, we are hopeful that we will soon have a robust legal framework for emergency arbitrations. Thank you.